Leases. A lease is a document creating an interest in a property for a term of years certain. It is any agreement which gives rise to a relationship of landlord and tenant in real property or lessor and lessee in real and personal property. It is an agreement under which the owner gives up possession and use of his property for valuable consideration and for a definite term, and at the end of the term the owner has absolute right to retake control and use the property. A lease is a demise of land from the lessor to the lessee or an interest or term less than that of the grantor, usually in but not compulsorily in consideration of specified sum called the rent. A lease is both a contract between two parties or an estate, the nature, extent, or quantum of interest of a person in a real or personal property. Features of a lease. A lease is an agreement of a term above 3 years and consequently must be by deed. B. The title to the land is not conveyed, only the use and occupation of the property is transferred. C. The relationship is for a fixed or definite period. D. The lessee may, subject to the conditions stated in the agreement, assign his interest or sublease part of his interest to another person. Rent is usually but not necessarily paid by the lessee for the use and occupation of the property. F. There is a right of reversion of the property to the lessor. Reversion. Reversion is the interest that remains in the grantor after the grant and expiration of the term in the future. The reason for reversion is because a lease cannot endure in perpetuity. Thus, in every lease, the lessor has a reversionary interest. Types of lease. 1. Oral parole lease. An oral or parole lease is usually not in writing. It is permissible under Section 3 of the Statutes of Fraud Act 1677. Essentials of an oral lease. A. It must take effect in possession. B. It must reserve the best to rent, not a premium or rack rent, i.e. the rent must not be paid in advance or in a lump sum. C. It must be for a period not exceeding 3 years. The drawback with oral lease is the difficulty of proving the essential terms agreed to by the parties. For a party alleging an oral agreement is duty bound to prove that such an agreement actually exists. Odutola and Papers Act Nigerian Limited 2007 of Federation Weekly Law Report 1214 at 1218. 2. Written lease. These a written agreement applicable to leases not exceeding 3 years. It need not be under seal. It is signed in the hands of the parties only. A written lease is binding upon the parties as a contract and is enforceable. Advantages of a written lease. A. The terms are easily ascertainable and enforceable. B. An order of specific performance may be ordered. C. Where specific performance fails, there can be award of damages. 3. Lease under seal. A lease could be made by deed. It is mandatory for leases above 3 years to be by deed. This will satisfy the requirements of Section 77 sub 1 of the PCL to the effect that any conveyance of land of any interest in land is void unless made by deed. However, the rule in Walsh and Lonsdale 1882-21 CHD 9 states that an agreement to create a lease will still operate as a lease, notwithstanding that it is not created under seal. This is based on the maxim, equity looks at the intent rather than the form. Essentials of a valid lease. The Supreme Court in Osho and another, and Foreign Finance Corporation and another, 1991, for Nigerian Weekly Report, part 184, page 157, sets out the requirements of a valid lease as follows. A. Words of demise. B. Complete agreement, leaving no ambiguity as to its purport. C. The identification of the parties to the agreement. D. The premises must be clearly identified. E. The commencement and duration of the lease must be clearly stated. F. The terms of a lease must be certain and ascertainable. G. The commencement and expiration date must be clearly stated. This is to ensure that the lease do not endure in perpetuity. UB and Tejumola and Sons Limited, 1988, 5 SC 26414. A lease that will commence when the first daughter of the family gets married is uncertain and thus is void. A lease that had no date has also been declared invalid. Also, a lease agreed to run until the landlord widens the road has been held to be invalid. Prudential Assurance Company and London Residuary Body 1992 3AC. A lease that was built to run for as long as the company was trading has also been held to be void. A lease agreement for a future lease is void unless a definite time commencement can be inferred from it. H. There must be certainty of commencement. This is to ensure that the duration of the lease is calculable. The word commencement is allowed for the purposes of the lease. I. The property subject matter of a lease must be described in specific dimensions. J. The lessee must have the right of exclusive possession. He should be able to exclude everyone from the property, including the lessor or landlord, except for the condition that may have been expressly provided in the agreement that the landlord may enter the property for repairs, or when there is a breach of any of the terms stated in the agreement. Exclusive possession and exclusive occupation. A person may have exclusive possession without being in exclusive occupation. Example is where Mr. A leases a house to Mr. B and Mr. B gives the house to his mistress. The mistress merely has exclusive occupation, and this is because the lease is in the name of Mr. B. Mr. B therefore has exclusive possession but does not have exclusive occupation. Similarly, a person can be in exclusive occupation without having exclusive possession. A perfect example is where the landlord of the property lives downstairs and the tenant lives upstairs. The landlord keeps interfering with the occupation of the property by tenants. Thus, tenants are in exclusive occupation and not in exclusive possession. Certainty of parties. The parties to a lease must have capacity to contract the lease agreement. The parties may be natural or juristic persons, UBA and Tejimola & Sons Limited, Supra. The owner of the property who makes the grant is the lessor landlord. The person who takes over the exclusive use of the property is referred to as the lessee tenant. The lease must be created in a proper manner. Where it is for 3 years and above, it must be by deed. Where the lease is for a term below 3 years, it may be by agreement under the hand of the parties. This may simply be referred to as a tenancy agreement. Determined rent. This may or may not be required in a particular lease agreement. Frankly speaking, rent is not an essential of a valid lease. Distinction between a lease and an assignment. For a lease, it may not be created by deed. Only possessory interest is transferred. The lessor retains the reversionary interest in the property. There is no need for an investigation of title. For an assignment, it is always created by deed. Proprietary interest is transferred. The entire interest in the property is assigned. It is very important to investigate the title of the assigner as well. Distinction between a lease and a sublease. For a lease, there exists a direct relationship between the lessor and lessee. For a sublease, there is no direct relationship between the lessor and the sublessee. Distinction between a lease and a license. For a lease, there is a transfer of interest in property. The lessee has exclusive possession. Interest is transferable through a sublease. The demised estate can survive the death of the parties. The lessee can maintain an action in trespass against third parties. A lessee is entitled to the statutory notices. For a license, there is no transfer of interest in property. A licensee has no exclusive possession. There is no such right or interest that can be transferred. Death of the grantor or the licensee terminates the relationship. Licensee cannot maintain an action in trespass, and the licensee is not entitled to statutory notices. Very important, a license does not create proprietary rights. Street amount for 1985 AC 829 818 Eloichin Limited and Mbadiwe 1986, all NLR 1 at 14. Quick glance note is powered by Rooms and Luxury, your choice real estate agency in Lagos, Nigeria. Address is number 7 Tower Connie Close of Idemai Crescent, Igbefon, Lekki, Lagos, Nigeria. Tell WhatsApp 08142775425 091569137 and send your emails to roomsandluxury@gmail.com. Instagram Rooms and Luxury, Facebook Rooms and Luxury. You can call them for all your real estate questions. For sponsorship and advert placements, please contact 09125921620 or send an email to resistandpartners.chambers@gmail.com.